Good morning, Mr. Peterson. Good morning, everybody. Are you ready? Okay. I have had the opportunity of reading the replying affidavit. Do you want to just deal with the replying affidavit a bit, Mr. Peterson?
Yes, certainly, Chair. I don't know what you envisage for this hearing. I anticipated that it might be important to, since this is being broadcast and it's a public session, that those listening to and observing this hearing should know a little bit more about what it entails. So I'm ready, subject to your directions, to go through the essence of the submissions that I want to make, to deal with the opposing affidavit and to deal with the replying affidavit.
I don't mind if you want to take 5 minutes saying what you want to say, and in the process address whatever you might wish to address on the replying affidavit. Let me say this immediately so that also Mr. Madonsela can know what is going on in my mind so that when he rises, he knows what to address. Subject to something that I must just check in the replying affidavit, and that's why I wanted to just deal with the replying affidavit. Subject to that, and me finding that there is no problem in terms of what I'm thinking, I am inclined to grant some order. The notice of motion that has been put up might not reflect what I have in mind, but I'm inclined to grant some order to allow this witness to give evidence without any risk of his cover being blown, as it puts it. Exactly what the terms would be, we can look at that, but in principle, I'm inclined to do that. Obviously, that is subject to argument that may be addressed to me. I remain open, but when I was in practice, I always found that it was very helpful if the judge indicates what he's thinking, rather than you addressing all kinds of issues and you are addressing issues that the judge really has no interest in. So I give you 5 minutes to address me on whatever you want to address me on, but in the process, deal with, tell me more about what you have to say about the replying affidavit. You will remember that last time I did say that the minister's point in his opposing affidavit that this witness has given evidence in a disciplinary inquiry without doing so in camera was a point that needed a response. It looks like the replying affidavit does deal with that, but I read it once and I might just need to have a look. But as you address me, I will listen. But that's the inclination. Okay.
Thank you, Chair.
So in other words, I don't want us to take too long on this matter. We have oral evidence to listen to. So, but I will be fair to both parties.
Chair, as you're aware, I have prepared and put before you a draft order around which my submissions will be based. And the terms of that differ in important particulars from the prayers sought in the notice of motion.
Well, I don't know whether you're talking about a separate draft order, because I haven't seen a separate draft order.
It's in the bundle. It's in the bundle KK 1.4, and it's the first item.
The notice of application.
No, this is the draft order.
Where does it appear?
It appears in Exhibit KK 1.4, that's the bundle marked 1.4.
Yes.
And it is item 1.
Yes.
And that was drafted with the hope of saving time and allowing me to focus my submissions without, as you say, going off in all directions.
I'm just looking at the terms of the draft order. I had not seen it before. I think on the face of it, most of the order appears to present me with no problem, subject to what Mr. Madonsela might have to say and subject to hearing argument.
That being so, Chair, I propose then to concentrate, if I may, on the grounds of objection which have been raised and the response to those, and that may leave little or nothing necessary to say in reply. At this stage, however, I don't know what the submissions will be that Mr. Beloy may wish to make on behalf of General Mpego.
Yes,
and
I guess
may
you
need to
can.
deal with that.
All you can do is address those points that emerge from the opposing affidavit.
Yes. Now, may I proceed? 4 grounds of opposition to an in-camera hearing have been advanced by General Pele. 1. The first, in paragraphs 7 to 13 of his affidavit. Shall I give you the bundle reference as I go?
I think you may give me the bundle references, but if you give me the heading of the objection or in a very
Yes.
Crisp point to say this is the one objection, this is another one, this is another one, then you address them
Yes,
each.
certainly.
That will do, even if you don't refer to the bundles.
Fine. I have prepared submissions on the basis that they should be as concise as possible.
Yes.
And at the same time not leave any loose ends. But
yes, that's
again,
fine.
I'll be guided
Yes.
by what you want to hear.
Yes.
And the first objection is that Colonel Naidu, while under witness protection, has previously testified, and I quote, in the open, unquote, during an SAPS disciplinary hearing into the conduct of Major General Lazarus held from 2012 to 2013. In response, Colonel Naidu has stated that in fact, quote, those proceedings were not open to the public and were only attended by the participants in the proceedings and legal teams together with a number of persons from witness protection, unquote. The risk of exposing his new identity and location under witness protection was, in that context, I submit, minimal. Quite different are the proceedings of this commission, which, as I would happily develop if there were more time, these proceedings are required to be held in public unless there is reason for the chairperson in his discretion to order otherwise. The risk of exposing Colonel Naidu in this context is qualitatively quite different, and I submit has to be taken very seriously indeed.
I'll tell you what my understanding of Colonel Naidu's concern is, and you must just tell me if that is your understanding too. My understanding, and having regard to the opposing affidavit and the replying affidavit, my understanding is that both Colonel Naidu and the minister let me put this way. I'm inclined to think both Colonel Naidu and the minister know each other, or at least have met. But they might not have met. Even if they might not have met, it seems to me that the minister knows who Colonel Naidu is. That's the one point. But also, it's quite clear from the opposing affidavit and the replying affidavit that many, if not all, the persons implicated by Colonel Naidu know who Colonel Naidu is. And Naidu knows that they know him. Therefore, from that point of view, Colonel Naidu can't be asking for an order that would conceal who he is to the implicated persons. But his concern, it seems to me, is that the public and other people, other than those who are implicated, whom he knows, know him. The public and other people should not know who he is. That's my understanding of his concern. So that's why he talks about, that's why he says he doesn't want his cover to be blown. And if he has given evidence in a disciplinary inquiry, when those implicated persons were there, they know who he is. But as I understand it, his concern is, I don't want the public to know, to connect the face to Colonel Naidu. That's what I don't want. That's what I understand his case to be. Because if that happens, then the public or certain people who know where I live will then connect the face that they know by a different name to Colonel Naidu and say, oh, this is Colonel Naidu. And he doesn't want that because of what it will entail for him. But he also says, if that happens, namely his cover is blown, implicated person, it will not be difficult for the implicated persons to find out where he lives now. And that would put his life in danger. So if I'm correct in that analysis, it seems to me that as far as the implicated persons are concerned, he knows that they know him. They know the face of the Colonel Naidu that we are talking about. But he doesn't want them to know where he lives, because that might put him in danger. But as far as the public is concerned, he says they don't know that Colonel Naidu, particularly where he now lives, they don't know that Colonel Naidu is the person that they know by another name. And he doesn't want that to happen, because if his face is shown, or if newspapers write and show his picture and so on, then those people will then say, oh, this person referred to as Colonel Naidu is actually the person we know by this other name. And that would blow his cover. So does my analysis accord with your analysis?
Chair, what you have said captures the essential object of this application as I have evaluated it, and on the basis of which my submissions were prepared and the draft order was prepared in substance. I wouldn't want to go so far as to say that and there are no fewer than 45 people to whom Rule 3.3 notices were issued. I wouldn't want to go so far as to say that all of them have seen him.
Yes, yeah.
And therefore I cannot quantify in my submissions to you what the risk may be of additional persons coming to see him. And as far as the Minister of Police is concerned, first I want to just emphasize that this application is not about the Minister of Police. It's about the protection of the witness. And one has to take into account the number of implicated people. By implicated people, if I may just clarify, it means people who are or may be implicated by the evidence of the witness. I don't draw the conclusion from the papers that the Minister, who was Commissioner of Police, has ever set eyes on
Mr.
Colonel Naidu.
Yes,
or vice versa.
That's possible, yeah.
And he himself emphasizes in his reply that nowhere does he say in his evidence that he saw the general.
Yes, so he might not have met him.
No.
Yes, no, that's possible.
But to the extent that one is dealing here with an assessment of risk, of exposure in connection with the witness protection program, there would be very little additional risk if the Minister of Police were to see whether it's his face or a photograph. So he's going, oh, no, I don't know him, or yes, I do.
Yes.
But that is not essential to the evidence.
Yes.
And I must emphasize that if one goes through, there isn't time, but I would happily take you through the Rule 3.3 notice in relation to the Minister, that there is no direct evidence where Colonel Naidu says, I saw or I directly overheard.
Okay, okay.
And that rather changes the situation. So, but to confirm that the essence of the problem is the one that you, Chair, have articulated today.
Yes, yes.
But there is a dual purpose in this application and in the formulation of the proposed draft order, which is to maintain and protect the public's right to information and the media's role in facilitating the constitutional guarantee of freedom of expression, which includes freedom of information and freedom of the media. So one has to address the practical difficulties of conducting a hearing where the public have the access which they ought rightly to have, and where the implicated persons, none of whom have as yet, they still may, but none of whom have as yet taken steps in terms of Rule 3.4 to make a statement challenging the content of the evidence and applying to cross-examine. That may happen. But it is, to the extent that one is thinking hypothetically of what may happen, it is difficult to see how one would manage the combination of allowing the public to observe the proceedings and have potentially the 45 implicated people in another room with Colonel Naidu. So I would therefore persist, in order to achieve the appropriate balance between witness protection and the protection which not only does the policy of the Constitution, but I have no doubt the policy of the Commission is determined to ensure that implicated persons have a fair opportunity to challenge evidence which is adverse to them.
Yes, no, that's fine. You did say something that goes to a question I was going to raise, namely, to the extent that an implicated person might wish to see the face of Colonel Naidu wherever he will be testifying from. Is there a difficulty with that? Well, there should not be a difficulty with regard to those implicated persons that Colonel Naidu also knows they know him, I would imagine. But I don't know with regard to those that might not know him. But are you able to say anything about that?
Yes, I would suggest that there are two aspects to this which it would be helpful to distinguish. One is seeing his face for the purpose of recognizing that this is the person. The other would be observing him during his evidence, where the argument is put forward that demeanor is fundamentally important to fairness. I do want to make a short submission on that aspect, well, on both aspects.
Yes, yeah.
On the first one, I would imagine, and one has to use imagination here, I would imagine that it could depend upon the implicated person concerned answering the question to you, has he or she set eyes on Colonel Naidu before? If the answer to that is yes, then it seems to me there could be no serious security problem in allowing that image to be refreshed. If the answer is no, then the next question would be, why do you need it now? And it occurs to me that you may, if you are...
Well, the one who is in the position that the one who doesn't know him might be the one who might have a stronger reason to want to see him. Because he might say, I see this person that I don't know makes all kinds of allegations against me, but I actually have no idea who this person is, and I don't know who this Colonel Naidu is. But if I were to see his face, I might recognize, oh, this is the person. I didn't know his name is Colonel Naidu. And then I'm in a better position to answer the allegations because now I know the person, I can connect the person.
My submission in response to that would be that conceivably is a practical necessity that could arise. And that is why I suggest, and I've got another suggestion to attach to that, why I suggest that the question should be answered, what is it that makes it necessary for you to see him now? Because in preparing, even if the response under Rule 3.4 has not yet been finalized and delivered, in the course of preparing such a response, that implicated person could surely be expected to articulate what it is in the content of the implicating evidence, all of which has been provided in the Rule 3.3 notices. What is it about the content which I have difficulty responding to because I have not seen Colonel Naidu? And so it may be that you would be disposed, if you are inclined to follow the draft order in most respects. If you look at paragraph 2 of the draft order, which allows for a variation, but the circumstances that are mentioned there are perhaps too narrow. They deal with if, in your opinion, Chair, circumstances warrant a variation to ensure the protection of Naidu or any other person in connection with Naidu's evidence. But the circumstances which have just been hypothesized could provide another ground for a particular and ad hoc variation, which could be catered for by a rewording of 2.
Maybe the variation part should be formulated in such a way that it says, I may vary the order, vary or amend the order in such way as I may consider necessary, in such way as I may deem necessary. And I'm saying necessary in the context of necessary in balancing the various interests, the interest for the protection of the witness and the interest of trying to limit any infringement of or interference with an implicated person's right in one way or another to the absolute minimum. So that kind of balance, that's what I'm having in mind. Maybe that a different formulation might be okay as well.
I would propose that as much as possible of the detail of the wording of paragraph 2 should be retained, because there's the protection of Naidu or any other person in connection with his evidence. I'm not sure what's going to come out that may need some special order.
That's right.
Or to ensure fairness to any implicated person.
Yes, that's the kind of thing. So what it would mean is that if I grant this order, then at any stage in the future, while Colonel Naidu is giving evidence, or if I grant leave for somebody to cross-examine him in the future, I can memo to or on application by an implicated person amend it where I consider that it's necessary to do so for purposes of fairness to all concerned.
That's my submission.
Yeah.
Now, the other aspect was demeanor.
Yes. Well, I must just tell you that I'm on my 23rd year as a judge, and I can't recall one time when I decided any case on the basis of demeanor. That's what I can tell you. I can't remember. Maybe there is one or two, but I have no recollection in all these 23 years, 22 and a half years of having decided a case on the basis of placing a high regard on demeanor.
Chairperson, may I just add one point to that? With all due respect, and with no similar experience whatsoever, I'm less confident that demeanor is never a factor.
Yeah. Well, I've no doubt that there are maybe some presiding officers, maybe, I don't know whether I should say maybe more in the lower courts than in the high courts, but maybe everywhere. But I know also of a number of judges who would speak in the same way to say demeanor, is such a difficult thing, particularly in our multicultural, multiracial society. It's not a lot of us, or some of us, don't find it easy to rely on that. Usually, there is more than enough in terms of probabilities to decide a case.
To be fair to the Minister, he was dealing with a notice of application which asked for the witness's voice to be distorted as well as his face to be concealed. In the draft order, you'll have seen that I'm not persisting with that. Indeed, I think that is unnecessary to the extent that it would be wrong. And secondly, that Colonel Naidu himself said in his supporting affidavit that he does not mind if his voice is heard. And his protection, his protectors are satisfied with the arrangements that are envisaged in the draft order, something that has not been easy to achieve, the practicalities. But it seems to me it's quite important, if I just add this on that the Minister has invoked findings in the disciplinary proceedings that took place some years ago, which were presided over by Mr. Pretorius, SC, and that he made certain adverse or cautionary findings in relation to the evidence of Colonel Naidu.
As a matter of interest, did Mr. Pretorius rely on demeanor?
There was, that's exactly my point. I can find nothing in his findings which suggests that they relied in any way on demeanor.
Yeah, okay.
Chair, is there any other aspect which you'd like me to address now?
No. I think I'm keen to hear Mr. Madonsela now. Thank you.
Thank you,
Mr. Madonsela, you have the benefit of knowing what's going on in my mind.
Indeed, Chairperson.
Yes.
A substantial part of the interaction which Chairperson has had with my learned friend has taken out of my argument certain steam that I was coming to this Chairperson, to this in commission with. In principle, we have no objection to the augmented or amended draft order, save in relation to two aspects which have been raised during the interaction with the learned friend.
Yes.
And those conditions are mainly in relation to whatever the order should be in relation to the in-camera proceedings. We submit, for the reasons which I will advance in a moment, that it should accommodate or permit the implicated persons as well as the legal representatives to see him, because they have already done so in the past. And secondly, that whatever the embargo or the in-camera order should contain, it should sanction as well that any response given by the implicated persons to the allegations made against them should similarly be embargoed to the extent that it may blow cover to those individuals who are referred to in the statements of Colonel Knight. Those are the two.
I think that's similar. That's very important, I think.
Those are the two conditions which we would like to place to any amended order.
Yes. Just go back to the first one. Let me just hear the first one.
The first one is that an amended order should permit the implicated persons and the legal representatives representing them to be able to see Colonel Naidu when he testifies, or at some point. At some point.
Not necessarily to be there throughout the testimony, but at least to see his face, and then so that they know the face.
That this is the person who's testifying.
Yes.
As you said, for the position of the minister, he meets so many Naidus in Durban. Chairperson, you know that there are so many Naidus in Durban.
Well,
and he was a national commissioner.
There are also a lot of Zondos and Madonzelas.
And he was the head of the national police services. There could be so many Naidus. He wants to just be certain in his response. I'm actually talking about the very man that is testifying, at the very least.
I must say that when I read his affidavit, that the minister's affidavit, opposing affidavit, it gave me the impression that that he was talking about somebody that he knew. But somewhere else in the affidavit, he seemed to give the impression that he didn't know him. But it may be that it's the way he was talking about Colonel Naidu's testimony at the disciplinary hearing. It was as if it was somebody that he knows, but I accept that he doesn't know him. But I'm just linking that to what I said earlier on. It had given me that impression, but I accept that he says he doesn't know him.
Well, no, the position of the minister is that he may know him, he may not know him.
Oh, okay.
He just wants to ascertain that very fact.
And he just wants to see the face and be able to say, oh, it's somebody I know, or it's not somebody that I don't know.
Yes.
Okay. So that's the first point. And then the second one, you just articulate the second.
The second one is that if any embargo or in-camera order is to be granted, it should also or similarly apply to the responses given by the implicated person, certainly the minister, insofar as it may blow the cover of those who are connected with the responses that he is giving.
Yes.
Because it would be unfair, Chairperson, to allow Naidu to publicly indulge in the slander of implicated person under the curtain of secrecy that they want it to be built around him. The fairness must dictate that if he wants to do that, if he wants secrecy to be given to him as a cooperative, as a member of the intelligence at the time, a similar protection should be given to those who are involved in the entire activities of the intelligence services.
I'm not sure if I follow the second point, and I want to make sure I do. I thought what you were saying earlier on was that an amended order should also say something to the effect that in whatever the minister or his legal representative may say, maybe if he is granted leave to cross-examine, maybe, I'm not sure, they must be careful not to say anything that might blow the witness's cover. I thought that's what you were saying. Was I right?
You are right. That and also the cover of those people who were connected with the activities in relation to which Naidu testifies about in his Rule 33 notices.
Oh, okay. It may be that what you are talking about is what we did last week in regard to Colonel Rulofse. When Colonel Rulofse was testifying, and a lot of people he was testifying about were in the crime intelligence department or unit of the SAPS, he was implicating a number of people, some of whom could be agents, and I think at that stage there was no certainty who was an agent, who is not an agent. Rule 33 notices had been sent to them, and it was decided that in his evidence and in his statement, he would not refer to them by their names. He would give each one of them a number. I think there was, for example, F1, F8, F6, F whatever. So, but the names were provided to me in a sealed envelope, where at some stage I could have a look and see who is F1, who is F8, and so on. But that was on the basis that an approach has been made to the relevant authorities by the Commission's legal team to say, of these names, tell us who should really be protected, But until we know who shouldn't be protected, we'll protect everybody. But is that the kind of thing you have in mind?
That's the kind of thing that we have in mind, Chairperson. We base that on the contention which I wanted to make later, that there is an inevitability in the evidence of Naidu that in response, a cover of certain intelligence services operatives will have to be blown.
Yes, but
it is that protection that we want to safeguard.
Yes, are you now, is what you are saying going as far as saying when those implicated persons come to give evidence, they should also be afforded the same kind of arrangements in terms of in-camera hearing?
Yes.
That's what you are saying.
I
think what we should do, let's not decide that now, because that's not before me. But if and when a person who is implicated wants to give evidence and they want the same arrangement, then they can bring a similar application and then it can be considered. Yeah, but I think we note what you have said and I think it's important, but I think it's they would have to bring an application at the right time and then it must be considered. Other people must get a chance to oppose if they want to oppose, and then a decision can be taken.
Yes. I will say very little about demeanor because because much of what has been said
applies to you as well.
Well, Chairperson, I suspect the reason why demeanor has not featured very prominently in your judicial life is probably because of the nature of the proceedings in which you presided.
Yeah.
There may be adversarial proceedings. These are inquisitorial.
Yeah.
They somehow depend on the truth, the truthfulness of the witnesses.
Yeah.
The demeanor might chip in. This is precisely the position here because of the KG responses that NADU has given in the affidavits which are currently before you in relation to, you remember in the founding affidavit, he said, Kelly arrived and I was there. And what was that? What that was meant to allow the chairperson to draw an inference that they may have seen each other. Now, in reply, he says, no, well, I'm actually not, I must clarify myself. I didn't see Kelly.
Yeah.
So all that he's talking about is pure hearsay from people who saw Kelly on some other occasion.
Yes,
but to the extent that this chairperson could have drawn on the evidence that he has given in the 3.3 notice, it could easily have been that an inference could be drawn against Kelly on the allegations he's made because of the impression that was created in those affidavits.
I understand that, but understand you to be saying you don't want also to rely much on demeanor. Am I right?
I'm not sure.
Well, you don't have to waive any right to rely on it, but I'm just saying, I mean, demeanor is about saying, oh, when this witness was asked this question, I saw how he was shaken, or he looked down, or that kind of thing.
Well, yeah, demeanor is an unruled horse because it can be very deceptive.
Yes, but I think in order to save time, because I think what you have done is you have made clear that you are not opposed to the granting of the amended order. You have raised 2 points, which I think the second one relates to other people, really, and I've said when they want similar arrangements, they will apply and then will consider it. So it seems to me that it goes back to saying it's one point you really are concerned about, otherwise you don't have any quarrel with the amended order, and the point is about an opportunity for the minister, and it may be that one would not make it blanket to everybody as such, because maybe for some people might be appropriate to grant it, maybe for others I'm not sure. But your concern is that at some stage or another, the minister, you would ask that the order should be such as to allow the minister to see his face.
Yes.
Yeah. So I think let me hear what Mr. Peterson has to say about that, if there is nothing further that you would like to say.
I just wanted to qualify the issue about demeanor to say that we are not really pitching our case on demeanor per se. We're pitching our case on credibility.
Yes.
Precisely because this very witness, this very colonel, has been found to be an incredible witness in proceedings before. And more importantly, by the evidence leader of this very commission.
Did you say incredible?
Credibility, yes. Credibility.
Yes. He was disbelieved.
He was been found to be dishonest now. Not incredible in the sense of being excitingly incredible.
That's
but
fine.
Dishonest, yes. That's the element.
Yeah.
To the extent that in the future we intend and we will cross that river when it comes to cross-examine witnesses.
Yes.
To cross-examine the Naidu, depending on whether we're given an opportunity
Yeah.
to do that,
Yeah.
that his evidence might very well turn on his credibility, which we would like to attack,
Yes.
given what has happened before.
Yes. Maybe what we would, maybe what we'll do is, I'll hear what Mr. Peterson has to say about the issue of the order being amended in such a way that either implicated persons can see him, just to see his face, as opposed to observing him throughout his giving of evidence, as I understand it, see his face, or whether we should simply work on the basis that to the extent that any implicated person might wish to be allowed to see his face at any particular time, let that request be made at the right time and it be considered then, and we take it from. In other words, we don't exclude the possibility of granting that, but we say let it be dealt with on each one, let each one be dealt with on its merits.
Yes.
Yeah, okay. Thank you. Mr. Peterson?
Chair, I don't know if you wish to hear Mr. Baloyi first.
Or has he got some submissions? I'm sorry, I forgot about him. Mr. Baloyi?
Thank you very much, Chair. Chair, my submissions are going to be very brief.
Yes.
Chair, I represent General Mpego. He's one of the implicated persons. Chair, our submissions and my client's main worries are that it's essential for him to be able to put a face of General Naidu to his evidence. It's quite crucial. And as you're aware, Chair, it might help to unravel whatever that can be unraveled for him to be able to apply for cross-examination. So, Judge, we do not have a problem with the proposed draft order for as long as our client will be permitted to put a face to this evidence. Judge, that's the main crux.
And in that event, you don't mind whether it's a question of your client being allowed to see him in person or being given his picture? Or do you mind, in other words, if you are given a picture to say this is him, would that be okay?
Judge, I think it will be important for our client to see Mr. Naidu in person. It will be very crucial for us.
Okay, I think I'm inclined to say let the order be such that you are able, any implicated person is able to make an application at the right time to see him, and I would then decide each application or request on its merits. I'm inclined that we do it that way because there may be some who make out a good case and there may be others who might not make out a good case. So I think that should accommodate you because it gives you an opportunity later on to then bring such an application.
Judge, I agree. It may well be so as long as there's our client's rights are reserved to be able to see the face of Mr. Naidu.
Yes.
That will be in order, Judge.
Okay, no, that's fine. Thank you. Mr. Peterson? Oh, Mr. Madonsela, you want to?
Before Mr. Robertson replies, there's a matter which has been raised by my junior, Mr. Mlala, here, which may be of some importance if it carries some weight.
Yes.
An attention has been drawn to the provisions of Section 15(1) of the Witness Protection Act, which I would like to read into the record. It says, in any civil proceedings in which a protected person is a party or a witness, may, subject to subsection 2, be proceeded with in terms of the law regulating such proceedings. And subsection 2 says, if it appears to a judge of a High Court in an ex parte application made to him or her in chambers by a director. That safety,
I'm sorry?
by a director.
Yeah.
That safety of any protected person might be endangered by the institution or prosecution of any civil proceedings in which the protected person is a party as a witness. And proceedings is defined in the Act to include also the commissions of inquiry appointed in terms of an Act of Parliament. What Malana Jr. Has drawn to my attention is that in these proceedings, the application for a protected person to be placed in camera has not been brought at the instance of a director. In fact, the director does make mention of the fact that he has no problems with the safeguarding the safety of the witness. And it might very well be that that consideration is fundamental to the outcome of the application, because at paragraph 34 of the founding affidavit, Naidu does in fact make it clear that his safety has been assured by those who are taking care of him in witness protection. So it might very well be that this application ought to have properly been brought at the instance of a director who is defined in the Act itself. And to the extent that it has been brought at the instance of Naidu himself, whose credibility is at stake in these proceedings, it might very well undermine the very essence of the truth of which underpins this application. I thought we should bring that into the attention of the chairperson so that it might feature.
No, I think that's important. It may well be. I've no doubt that the director is aware, or I think he would be aware of the application, and I've no doubt that he would support it, because it may be that if there is nothing indicating that what his position is, it may be that a document may be obtained from him that says something like, I'm in full support of the application.
It might be critical to legal purity.
Yes, no, I agree, I agree. Thank you very much. Thank you. Mr. Peterson?
I'd like to begin with the last point.
Yes, I'm trying to look where to find where the Act is.
KK 1.4, item 3 is the Witness Protection Act.
There are too many of these files. I think they should be, all of these things should be put in one big lever arch file with dividers, if possible. Yes, I've got the Act, so we go to paragraph, section 15.
Yes, but just before I go there, Chair, the definition of proceedings, that's on paginated page 15 in the red numbering. Means any criminal proceedings, proceedings before a commission, etc. So clearly it's correct, as my learned friend said, that these are proceedings. But if we go to section 18, before we come to section 15.
Section 18.
Yes, that's on paginated page 29.
Yes.
Notwithstanding any other law, the presiding officer at any proceedings or at civil proceedings.
Yes.
So it appears that civil proceedings could be specially referred to. Civil proceedings don't embrace all proceedings.
Yes.
So then if we go to section 15, that's paginated page 26. Section 15 is specially dedicated to civil proceedings.
Oh, yes, yes.
So my submission is that it doesn't apply.
So it looks like your submission is that the circumstances where an application for in-camera proceedings should be brought by the director are circumstances where we are talking about civil proceedings.
Exactly, formal civil proceedings.
Yeah, I see the heading is civil proceedings in which protected person is a party
Yes.
or witness.
Yes, and then
And
sub
the-
1, any civil proceedings.
Yes,
So my submission is that that's not
it's not the only
it's not
proceedings.
relevant.
And the definition of proceedings includes proceedings before a
Proceedings in
commission.
general includes the commission.
And then 18 refers to any proceedings, at any proceedings as well as at civil proceedings.
Yes. So the
So that
legislature
means-
appears to have had a distinction in mind.
So that 18 suggests that in some places the statute talks about what applies to civil proceedings only, and in others it talks about what applies to both civil proceedings and other proceedings.
Doing my
And-
best, that's the interpretation I would also give to it.
Yes, that seems to be the case, yeah. Okay. So what do you say about Mr. Madonsela's only point? Because the other one we agreed.
My submission is that it would be adequately catered for by the variation of paragraph 2 of the draft order, and to which it has been suggested that some words be added. But even before the adding of those words, if I could just read to you a paragraph which I prepared on this question. It may occur at a future date that the Commission receives and the chairperson grants an application to cross-examine Colonel Naidu, but one could add that will give evidence, by an implicated person whose own identity needs to be protected from public disclosure. For example, by virtue of the secret work that the implicated person is engaged in on behalf of crime intelligence or another law enforcement agency. In such a case...
No, I think that has been, I think that's the one that we agreed should be dealt with if and when an implicated person applies for similar arrangements.
If that's agreed, then
Yes,
I can stop.
We don't have to put that in this order.
Then,
Yeah.
no,
The
then I can
point that-
stop.
Yeah,
Yes.
the point that, the only point that Mr. Madonsela raises is that he would like his client to have the opportunity, the order should
Yes.
allow his client to, at least at some point, see the face of Colonel Naidu. And I've indicated, and I don't think he has a problem, I indicated to Mr. Baloyi, but that would apply to him as well. That maybe the best way to deal with that is to ensure that there is nothing in the order that prevents any implicated person in due course to apply for an order that they be allowed to see his face. And I would consider each application on its merits and decide it. I don't think Mr. Madonsela has a problem with that. He doesn't have a problem with that.
May we do that by way of a further refinement of paragraph 2?
Maybe it might be appropriate to simply include an order, in the order, a paragraph that says something along the lines that nothing in this order precludes an implicated person to is it to bring or from bringing? Nothing in this order prevents an implicated person from bringing an application for an order that would allow him or her to have sight of Colonel Naidu, so that then they can bring that application.
That would make it clear, Chairperson, but it is covered by 2.
Yes.
But it may be advisable just
to include it.
for the avoidance of any doubt,
yes.
to elaborate it accordingly.
Yes.
And in regard to the bringing of an application, fine, but I wonder, Chair, whether it wouldn't be wise to provide that you may also do that mero motu.
Yes, maybe we should be able to do that, because I might decide to do that mero motu, yeah. So I think...
There's one remaining thing, if I may.
Yes.
I am concerned about the suggestion that that it should necessarily involve, if you allow it, that it should necessarily involve meeting Colonel Naidu face to face rather than seeing a photograph, because he is at a location which we don't know under witness protection. The logistical and security difficulties of bringing him to a place away from that location, each time an implicated person persuades you that it's necessary to see him, could create an untenable problem. So that if it's possible to achieve the object when you are so minded to order it, by the showing of a photograph, that should be the preference.
Yes.
And if I've understood correctly what has been said, that too would have to be motivated.
Yes, I think what the addition to the order should make reference to both having sight of Colonel Naidu or being shown a picture of him, so that when an application is made, one of the issues that an implicated person would have to address is, why should I see him in person? Why is it not enough if I'm shown a picture? And depending on what Colonel Naidu himself or the commission or the director may put up in terms of logistical challenges of bringing him out to each time an implicated person wants to see his face, that can be gauged against showing a picture to say what's the problem with that.
Indeed,
yeah.
Chair.
So if you include that in the order, it will remind all of us as I deal with that application to say there is the option of seeing a picture. What's wrong with that? Okay. All right. So I think therefore.
Chair, sorry, one more thing. I just wouldn't like to be misunderstood by silence as agreeing that an implicated person, it happens to be today Mr. Beloy's client, can satisfy you by simply saying it is essential.
Yes,
that my client must be able to meet him face to face.
Yeah, no, that's true. I mean, that's because I'm not deciding that, and I've said yes. An application would have to be brought. One doesn't have to deal with that. His client would have to bring an application, a proper application, which would be considered properly.
And would usually involve addressing to some extent the context,
yes.
the content of the Naidu evidence, yes. and why seeing him in that context is necessary.
Yeah, no, that's fine.
Those are my submissions.
I think what I want to do is, because I'm taking it that there's nothing further that anybody wants to say. I think Mr. Matonsela has one more thing.
There's a rejoinder that I want to make in relation to the photographer submission.
Yes.
The premise of our concessions was that the witness will be brought here and be placed in a separate room and be seen by yourself. That is the draft order that is before you. It is nothing. It is not a quantum leap to ask in those circumstances that a witness or implicated person should go into that room and see him and come back, rather than a photograph. I'm just less confident about photographs.
Yes.
Because of their ability to be easily manipulated. I've seen my photos being manipulated on social media, and many other important people in this country have been manipulated in photographs. I don't like that. I feel very uncomfortable with the photograph.
No, that's fine.
Provided probably maybe as a via media, if that photograph will be shown to you to reflect it is the same person that you have seen. Because if that person, as it is proposed in the draft order, that he will be here, kept in a separate room, and testifying from that room, then it should be easy to identify who he is.
Well, I understand what you are saying, but exactly where he will be, whether it's in the same building or in an adjacent building or many blocks away, is something that I'm not certain of now. But when I was reading the draft order, there was a place where, when I came to it, I thought, I don't know whether this suggests that it would be in the same building, but my understanding is that it need not be in the same building as long as measures would be taken to make sure that his voice, his evidence would be heard here. But I think that with regard to the question of whether an implicated person should be allowed to see his face or see a picture, we must leave that for later, because I'm not going to decide any application today for that. If and when an application is brought, then the implicated person can address the question of why it's more important that he should see the face rather than the picture more pertinently. And to the extent that Colonel Naidu might oppose, he can deal with that as well, or the commission at that stage. And if there will be logistical challenges in getting him seen by people, those will be put up and the implicated person can deal with them.
I wanted just to say one about the photograph. I wanted to say about it, if it is to be sanctioned by you, Chairperson,
yes,
it should be sanctioned on the basis that that photograph should be a photograph that must be approved by yourself, because you would have seen him.
Yes, no.
So that you avoid
any
distortion.
Challenges. Yeah, no, that's fine. That's fine. Thank you. Okay. Mr. Peterson, I think...
Chairperson, sorry. I've just been asked to make it clear so that there's no public misunderstanding that, in fact, the draft order doesn't specify the location of the separate room.
Okay, no, that's fine. I think maybe it might have been the reference to a separate room that might have given the impression that it's a separate room, separate from this room, which might have given me the impression it's a room somewhere here as opposed to anywhere, but it's wide enough. Yeah, but let's finish now so I can start with the oral evidence. So I don't propose to make the order now, because I would like you to amend it as we have discussed. But in substance, I am prepared to grant it, subject to being satisfied about that. So I would like you to amend it in accordance with the discussion and bring it later during the day, and then I can read it out. So, but to the extent that Counsel, Mr. Madonsela or Mr. Boloi may need to be excused so that they don't have to wait for that time, I'm quite happy to excuse them, but they can make arrangements to obtain the order if they wish to.
I assume, Chairperson, that the witness who's testifying is not the one who was Naidu himself, who was scheduled to testify today.
No, he's not testifying today.
Oh, yes, sir.
Yeah, no, he's not testifying today.
Yes,
It's a witness that we started with yesterday. Or maybe let me say this. He was originally, I think, meant to start testifying today. That's one. But two, we must still finish another witness. Now, with us only finishing this application at this time, I doubt that this other witness will finish while there is time to start with Colonel Naidu. I'll hear what Mr. Peterson or whoever from the legal team might have to say, but it doesn't look like to me that he could start today. But let me hear what they have to say so that you have clarity.
yes, and we just want to know at what stage should we make ourselves available for his testimony so that we
Yes.
can,
No, I understand.
as the issue.
Oh, because you want to be here when the evidence is given by him. No, that's fine. Who's going to deal with it? Is it with Miss Venson?
As I sit down, might I just say that if the chairperson does have time to look at section 18,
Yes.
he will see that at the end of section 18, there's again reference to the director,
Oh.
unless the director says something. So it's
Yes.
not really that the director is irrelevant, but
Okay.
he's always relevant in all proceedings.
Okay, all right. Miss Venson?
Chair,
Yeah.
I'm involved in leading the evidence of Mr. Naidu and Mr. Khuba, and I agree with your assessment. Because of the time that the application has taken, it's very unlikely that there will be time to start Colonel Naidu's evidence today.
Yes.
And I think that it's safe to say that
We'll
evidence will
start
be
with
led
him tomorrow. Yes. Okay. No, that's fine. That brings you certainty. Now, in terms of sometimes we decide as we finish at 4 o'clock or 5 o'clock what time we'll start the following day. Sometimes normally we start at 10, but sometimes we start at 9 or 9:30. I think we must work on the basis that we will start at 10, but should I decide later on that it will be earlier, then the legal team, Ms. Wenzel, will make sure that they let you know. Yeah. Okay. All right. So
It means we sleep over.
yeah, no, you sleep over. Okay, all right.
Chair, just for my own protection, I do wish to make it clear that I was asked to come in just to deal with this application. I have no other involvement
Yes,
in
okay.
relation to the law enforcement witnesses.
Yes, no, that's fine.
Might I also mention, Chairperson, it might not be me who's present here. It might be my junior. It might be those instructing us. To that extent,
Yeah.
if I'm not here, it
Yes.
should not be. It's not because I'm disrespectful to the chairperson. It's because of some other arrangements that I have to make.
No, that's fine.
But that's the decision which will be made in the course of the day today.
Yes.
And Chairperson, as I sit down, might I also thank you for
Yes.
extending the courtesy to us yesterday to make sure that we know that the matter is starting at 11. That information was conveyed to us in time. And
Yes.
it really did help us rearrange our affairs.
Okay,
Thank you for that.
Thank you. Okay, so I'll make the order later in the day. Maybe we should aim for 2 o'clock, Mr. Peterson, when we come back for lunch. If it's ready at that time, then I could make it at that time.
Skipping lunch, that's quite possible. And I have no difficulty with that.
So I'm going to take a short break now to allow Ms. Wenzel to organize before we continue with Mr. Khuba's evidence. We'll adjourn and we'll resume at 12:20. It is 12:05 now. We adjourn. when Mr. evidence in April or whatever month it was, and when Mr. Sissoko gave evidence yesterday and the day before, they were not asked to deal with the reasons given by workmen's in their report for the findings that they made against them. That should have been done. And it should be done with Mr. Khuba as well.
Yes.
Please make arrangements to ask both Mr. McBride and Mr. Sissoko to provide affidavits in which they engage with that report head on in terms of the findings that were made against them and the reasons and analysis on which those findings seem to be based, and deal with them and indicate what they admit is true, what they don't admit is true, and say what they have to say about the reasoning and the analysis in regard to each finding.
Yes.
Obviously, it may be necessary that a member of the legal team interview them and prepares that affidavit for them. But if they offer to prepare the first draft and give it to the legal team to have a look at and then settle it or finalize it, that's fine. But we should, in regard to these three witnesses, have a full and proper engagement by each one of them with the findings and the reasons given by workmen's for the findings against them.
Yes, I'll ensure that that is done.
Okay, and then once those affidavits are there, we can see whether it's necessary to call them or not. But that will be helpful for when Mr. July or somebody from workmen's comes here to give evidence about that report and their investigation.
Yes, I will ensure that that is done.
Okay.
Chair, now that we have digressed, I just want to inform you of something. You asked me yesterday if there had been a response by Ms. Mbeki, and I said no, they hadn't. And they hadn't, but last night at 10 o'clock, the Commission did get a response. And in that response, she says she would like to put her side of the story, and she would like to come to the Commission and make a statement. And
yes, no,
I'll
that's
make sure that arrangements are made for that to happen as well.
no, that's fine. That's important. I was asking because I thought it would be important for her to give evidence, to hear from her. I think that you people must be in touch with her to see whether she would prefer that she be interviewed by a member of the legal team or the investigators to prepare her statement or affidavit, or whether she has her own lawyers that she would use to prepare, because the best way to do that is for her to look at the statements and, if necessary, the evidence given by these three witnesses, but they all seem to say the same thing about her role. And maybe seeing what they say in the statement is enough, because I don't think that in their oral evidence they add anything that's not in the statement. she can look at those statements and then prepare an affidavit that responds to those allegations and explains her side of the story. Once we have got that affidavit, then arrangements can be made for her to come and give evidence.
Yes, thank you.
Okay.
Okay, Mr. Khuba, you say that the statement was leaked, and you said the content of the statement was leaked. Could you just explain what you meant by that?
What was clear on the article was the part which Colonel Madulonga indicated that he saw the vehicles, which seemed to be the vehicle of diplomats, and then he approached them and they indicated that they were going to arrest some people in the country, and they would want to see General Dramat. That part came out very, very clear, and the statement of Colonel Madilonga was not only about that. He kind of really lay a broader explanation in terms of assisting Captain Maluleke in getting those people across to where the Zimbabwean police were. But that part was not really covered. It was mainly on the issue of the role of General Dramat.
Thank you. And after you had expressed your concerns to Advocate Museng, what did you do?
I then approached the Acting Executive Director, Ms. Kukimbeki. Firstly, I had to explain to her the challenges I had, and then I wrote a letter requesting that each and every team member of the task team be polygraphed so that we could see who compromised the investigation of the case. She was at the first, when I was talking to her, supportive. That's why she requested me to put it in writing, of which I did. But after that, nothing came out of it. I also discussed with Advocate Musing, who was guiding the investigation, and he shared the same sentiment and said to me he will also voluntarily submit for the polygraph test. And because it was not arranged from our side, or the plan could not materialize, it was finally not done.
And the letter that you addressed to Mbeki, is that the letter that appears at page 49 of the bundle, dated the 31st of October 2013?
That's correct.
1 second again, Ms. Wenzel. I realize that it seems that I've got 2 sets now of the pages that I didn't have at some stage yesterday. It looks like those pages may have been located in a wrong place in the statement. So I now have 2 sets. May I return
Yes, please.
the ones that were lent to me?
Thank you.
Okay. So if you can hand them over to them, they probably need them unless they have already made other copies.
Thank you very much.
Yeah, okay.
Did you also discuss your concerns about the safety of the witness to Colonel Mukankwe after the statement had been released or published in the media?
Yes, I did. I still remember very well that when he saw that I was really worried about the safety and the leaking of the information in the docket, he said to me that why are you worried? Because your superiors are not worried. The minister will not ask you about that, and your superior will not ask you about that, which I understood him to refer to Ms. Mbeki. Of course, it happened that way because I never received any, I was never called. And in that part, it was me who was more concerned about it rather than Ms. Mbeki.
And what impression did you form from this lack of concern?
For me, I understood they were okay with it. That's how I took it. If then, because for me it constituted a compromise of investigation. I just thought probably they were okay with it. They never had a problem with it.
Mr. Khuba, in paragraph 37 of your statement onwards, you deal with your dealings with General Nklemeza with regard to this matter. Could you please explain that to the Chair?
At that time, General Nklemeza was the Deputy Provincial Commissioner for Limpopo. I was the provincial head. So from the operational point of view, we had a lot of contacts where I requested assistance even before I dealt with the rendition case. Now, one time around 2013, it was after I obtained the statement of Colonel Madilonga that he requested to see me at Wimpy. It was not really far away from where he was staying. Then I obliged to the request, and when I arrived there, I found him with few gentlemen, and one of them was introduced as an officer from Eastern Cape.
Thank you. Just if you can just address the Chair so that he can just see you nicely when you testify. Thank you. So he said he was with an officer from the Eastern Cape. Do you know the name of that officer?
I can't remember because the name I took it, I was writing on a note sticker on the phone. I will use my finger to write, but unfortunately it's a phone that I used long time ago, but I could not really take all the details. But what he said to me, he said he was attending a course or training in Cape Town with Captain Maluleke, when Captain Maluleke confided to him about what happened in the arrest of Moyo. Moyo was a wanted person for various cases, and according to the information they told me, they said he had slipped out of the country, went back to Zimbabwe. Now, this officer said Captain Maluleke told him that he went to Zimbabwe and he posed as a doctor after they took the Zimbabwean police arrested Moyo, shot him in the leg, on the leg, and then went to the authorities there and introduced Captain Maluleke as a doctor who would want to treat Moyo in South Africa. Now, this
That was very strange. Somebody is shot in Zimbabwe. You say you are a doctor, you are in Zimbabwe, but you are the one who says, no, I want to treat this patient in South Africa.
That is how I got
There are no doctors in Zimbabwe.
the story.
That's the story, yeah.
So what I did, for me, I did not take it lightly. I shared the information with the prosecutor, And how I perceived it, I thought, apart from the allegation of him being shot or the Captain Maluleke posing as a doctor, I thought probably it might have been an issue that when he assisted the Zimbabwean national, he was really returning the favor. That's why I took a bit of interest on the story. I then...
Mr. Khuba, before you proceed, I just want to clarify something.
Okay.
You said that it was told you, to you by this man that Captain Maluleke had been party or was present when Mr. Moyo was shot.
That's correct.
And then he posed as a doctor, saying he wants to bring him to South Africa for treatment. But what happened after that to him? What happened to Mr. Moyo once they got him into South Africa?
They said when he came into the country, then he was arrested. And then he was made to face those other charges. I did an investigation around that because when I shared with Advocate Musing, he also took some interest, and he told me that he knows a prosecutor who dealt with Moyo's case. And he did his own investigation, and he managed to get some of the statements relating to the cases involving Moyo. And then he gave me the copies of those statements, and then he requested me to go to Musina and check whether he was ever admitted there or treated there. And also requested that I need to meet with Moyo and take his statement, just to find out whether there is corroboration. Now, I sent my investigators to Musina. We couldn't find any record. Now, I requested somebody from the department to interview Moyo, which was done, and a statement was obtained. There were somehow similarities in the story that he was shot by Zimbabwean police, but he never made any indication that Captain Maluleke was there or he posed as a doctor and said it's his doctor. No, he didn't make mention of that. Now, what really happened was that I had to do the cell phone records to check, given the statements which I was handed by advocate, to check whether Captain Maluleke ever crossed at around the time when this Moyo was arrested. And what I found was that he was around the border, but there is no indication that his cell phone ever lost network when he was on the other side. So somewhere, somehow, he was at the border, but I could not prove that he crossed the border and went to Zim. And the statement of Moyo never gave any indication that he was seen that side.
So, just to clarify, and then we'll deal with your various reports in some detail in time, did you include this reference to Moyo in the first report that you submitted to the National Prosecuting Authority?
I did. I did include it.
And after, was this before or after you received the cell phone records?
I can't really remember whether it was after or before, but I remember in the first or January report, it was included.
And in the later report, was it included?
It was not part of that report.
And why wasn't it part of the second report?
Now, when
Or
we
an
did the
amended
evaluation of that docket, we realized that we could not really find the nexus, the link between the arrest of Moyo and the deportation of those Zimbabwean nationals. So we felt that it cannot really be part of that. And I looked at it and says, I think I agree, because there was no evidential value of that information, because the link could not be made.
And you also said in your statement here at paragraph 42 that after hearing this version from the gentleman from the Eastern Cape, you also analyzed Colonel Maluleka's laptop. What was the result of that analysis?
The analysis was done for the entire laptop, which means we recovered both personal and evidential material. Now, some of the things that we recovered or managed to mirror image was the story of Moyo. And I was in constant discussion with the person who was doing that. And I said, print out everything regarding Moyo. And then she was able to do that. But it never gave an indication. That information, it just talked about Moyo, which it wanted. It did not give a lead to say that he was required to go there and take him, or he spoke with the Zimbabwean national. I could not find something of such sort. It was mentioned in those documents that Moyo was wanted.
For the sake of completeness, what was Mr. Moyo's name?
I need to have a statement to get the full names. I only know him as Moyo, and I refer him as Moyo.
Oh, because I didn't pick up the name on your affidavit, and it's better to mention his name as well, so
Yes.
that one knows there are many Moyos, just as there are many Zondos.
Yes, we'll.
No, I think we can be able to get
to get the name.
The name. I think the reason why I use the name Moyo is how we referred to him in our discussions and how he was referred to by Versmans.
Yes, no, it's just that it's important to know whether it was Albert Moyo, John Moyo, Jabulani Moyo, Sipho Moyo, or whoever, whatever the name was.
Yes.
Okay.
Mr. Khuba, at paragraph 45 on page 13 of your statement, you referred to a further meeting you had with General Nklemeza. Could you please tell the chair about that meeting?
I had a meeting with him where we discussed about Madilonga, and I think he is the one who started that discussion. And I then had to confide to him that I was really, really uneasy about his safety, because that was after
Mr. Matilonga's safety.
Yes. Because that was after the article on Sunday Time. And then he told me that he had transferred Colonel Madilonga to Beggarsford. And he even indicated that Colonel Madilonga was his man. I must not worry about that. And I still remember I could not take his word for it, because after that, I think it was some few weeks, then I drove straight to Beggarsford myself. And I met with him just to find out how he was doing.
Mr. Matilonga.
That's correct.
Yeah.
And I even spoke with him because I had a discussion with Musing about, Advocate Musing, about the issue of witness protection. But when I spoke with him, he said, no, it's fine, it's a big cop, he knows what he's doing. Then I left and I came back, and That is what I discussed when I spoke to General Ntemeza. But at that particular time, there was an issue that because the position in the department in IPID was vacant, the position of an executive director, and he had made mention earlier that
Was it vacant because somebody was on suspension? Is that what you mean? Or was it vacant because somebody had resigned or had been dismissed and the position had not been filled?
no, it was, I think the person who was appointed for the position had resigned, and it was Francois Bietman.
Yes.
And that's why Ms. Kukimbeki was acting. But what happened is that there was a time when she was not coming to the office, and I heard that she had taken an offer somewhere. But she continued performing the work of IPID. Now,
I'm sorry, let me just interrupt you. Just something that I wanted to ask about Ms. Mbeki. Prior to her acting as executive director, where was she? Was she part of IPID?
she was part of IPID, and she was head of legal services, which is one program. She was a program manager.
Or just
responsible
yes, for legal matters?
Yeah, for legal matters.
Oh, okay.
Yeah.
No, that's fine. And after she had stopped acting as executive director, did she continue as head of legal services, or did she leave IPID?
No, when she stopped acting, she was no longer in the department.
Okay.
There was a time when she was not in the office. I think if it was not 1 month, it might be 2 months, where we were told that she does not deal with anything because she's working somewhere, but she only signed financial documents.
Okay, okay. Okay, I'm sorry I interrupted you while you were continuing. You may or may not have forgotten what you were dealing with, in which case Ms. Wenzel will remind you.
No, I didn't forget. I was talking about my discussions I had with General Ntemeza. At that time, he had told me that he was going to be appointed as an executive director of IPID. And I was very happy because I thought I would be able to work with somebody whom I know because I was working with him at a provincial level. Then on that particular day, he said he wanted to tell me that the political principal have changed their mind. He's no longer going to join IPID. He will be joining the Hawks.
And now let's try and get the time frames, or rather a sense of when this was. It appears from what you are saying that the time when he told you that he was going to be appointed as executive director of IPID was separate from the time when he told you that he was going to be appointed as the head of the Hawks or something like that. Those were two different occasions, is that right?
Those were two different occasions because the first one was about IPID.
Yes, around when was that? In terms of the year,
Everything
maybe and month?
Everything took place in 2013.
2013?
Yes.
Okay, you can't remember more or less where about in the year?
I cannot remember in terms of, I have months.
Yes.
In terms of my meetings with him, somewhere it was September, sometimes it was October, around
2013.
Yeah.
Oh, okay. That was when he told you that he was going to be appointed as executive director of IPID.
That's correct.
And then when he told you that he was going to be appointed as the head of the Hawks, around when was that? Or is it around the same time? Same month?
There was not really
A long time.
big lapse of time.
Okay.
There was no big lapse of time.
So it may have been a matter of different weeks.
Maybe different weeks or, different weeks,
months.
probably.
Yes,
probably,
okay. Okay. Okay, now, with regard to the first one, you have put it very clearly that he said he was going to be appointed as the executive director of IPID. Now, I just want you to be sure that that's how he put it, and that he didn't say he was going to be applying for that position. Did he put it like, I am going to be appointed?
He never put the word application.
Yes,
He talked about political principles,
yes.
that they wanted him to head IPID.
Oh, okay.
He did not talk about
Yes,
the issue of
making
the
an application.
We did not even talk about the advert. The
Yes,
closing, the opening, what does it say? We never
Yes.
spoke about that.
yes. That was in regard to the IPID position.
That was regard to IPID position.
And then when he talked to you on the other occasion about him coming to the Hawks or being appointed to the Hawks, how did he put it?
He said he wanted, it was when we were discussing the issue of the report, because he indicated, how far are you with the investigation?
It's the rendition investigation.
That's the rendition investigation.
Yes.
And then I would tell him that I'm left with few statements. But I would not really go into detail in terms of individual statements who were not police officers.
Yes.
Mainly
yes.
when the person whom I wanted to obtain a statement was a police officer, I would confine to him because I knew that he was going to assist me. So that is when he indicated to me that your report is the one that is holding me from being appointed there. That is what he told me.
And what did you say when you heard this? Was there further discussion around this issue of your investigation holding him back from being appointed to the Hawks?
Not really, because I found it very, very strange. But for me, it never shook me out of him to say, I don't want to talk to him. I just felt it's like a good friend who spoke something weird. You still attached to the person. I just kind of really said, ignore, but it stayed in my mind. Hey, when he said that, I told him that I'm left with what I need to get hold of these people.
And you didn't focus on what he was
No,
saying?
I did not focus on what.
Yes, but you noted it.
I noted it, yeah.
Yes, yes. So yes, continue.
Mr. Khuba, from your statement, it appears that there were at least 3 different conversations, and now from your evidence, it's sounding like things were happening in 2 separate conversations. So if we can just go back to your statement, and if you can just clarify as to which is the correct, I don't want to use the word.
Maybe the way to put it, Ms. Wenzel, is not to put it like you giving him leading questions like that. Were there any other occasions when you had interactions with General Ntlhameza in regard to your investigation?
Yes.
Yes, tell me about them.
In October 2013, I was in my house watching television. That was after I had already given General Ntlhameza my wife's number upon his request, because he indicated that he does not want to call me directly because he thought probably there were people who were listening to my telephone conversation.
This is still in 2013, towards the end of 2013.
Yeah, it was 2013.
Yes. So on a certain occasion, he asked you to give, on a certain occasion, you gave him your wife's number.
Yes.
At his request.
At his request.
Because he wanted to call you on your wife's number.
That's correct.
Okay, all right. Well, maybe finalize that. He said he thought he didn't want to phone you on your on your phone because?
Because he said to me, there might be people who are listening to us. He does not want to compromise our discussions.
Okay.
Then I still remember he showed me a small cell phone, you know, the old type ones that do not have the internet and you can just receive or make call. And he says, he advised me to get one. And he even told me that if I go to a particular store, it's only 150. Now, the reason why I could not take the advice, I'm not good in juggling. I don't want to carry two phones.
Okay.
So that's why I said it would be very difficult for me. That's when he said to me, if he could use my wife's number. I gave him my wife's number. I also informed my wife. So on that particular day in October 2013, that is when my wife told me that Mhlekazi is at the gate.
Now, when you say on that particular day, you are not meaning the day on which you gave him your wife's number. You mean another day now.
That's correct.
Okay. Continue. On another day, your wife said to you, Umhlekazi is at the gate.
Yeah.
Yeah, take it from there.
And she gave me the phone to speak with him. And he said to me, I must instruct the security to open for him because he had something to tell me.
So the reason why your wife was saying Umhlekazi is at the gate was because, one, who was Umhlekazi?
I referred him as Mhlekazi, and my wife knew him as Mhlekazi on the basis that even if we're doing shopping and we'll meet him, I wouldn't say general. I would say Mhlekazi, and then we'll give each other hugs, and after that, and my wife knew as Mhlekazi, yeah.
And Mhlekazi is a term for showing respect, for respect? Mhlekazi. Is it like gentleman or?
It's like gentleman, but it's a cosaway.
It's like sir.
It's like sir. For me, I took it as sir.
As sir, yeah. It shows respect.
Respect, yeah.
Yes. So that's how you called him.
And that's how he called me.
And your wife also then called him like that.
That's correct.
Yes. Okay. So on this occasion, he had phoned. That is gentleman that phoned on your wife's phone. And said, I'm at the gate, and your wife conveyed that message to you and gave you her phone to talk to him.
That's correct.
Okay, all right. And what did he say to you?
He said he had something to tell me. I should instruct the security guards to allow him in because it's an estate. I then told the security guards, then he came in. When he was in, then he told me about the meeting he had, that he was at the airport and he met General Mudluli. And he told me that he was sent by General Mudluli to me.
The General Mdluli that he was referring to, was it General Richard Mdluli? Or did you not know who he was referring to?
I knew.
Who was he referring to? Which Mdluli was he referring to?
Richard Mdluli.
Okay, all right. So what did he say about him?
He said he met him at the airport. And I still remember something that I even omitted to put in my statement. Because he said, that man is going to be our next president. That's what he said.
Talking about General Mdluli.
General Mdluli.
Yes.
So I just smile and laugh, just laugh about it.
And General Mdluli was somebody that you knew?
Yes.
Okay.
Not personally.
Not personally, you just knew
Never
the name.
met him physically.
You knew the name and the face, or just the name?
The name and the face.
Okay, all right, yes. So he said that man will be
the next
the
president.
next president.
Yes.
Yeah. Mm.
Then after that, he told me that he's the one who sent him to me, and he is appreciating the work that I'm doing. And he said, if I'm anyhow seeing a suspicious vehicle following me while driving to Pretoria or in Pretoria or coming back to Limpopo or anyway, I must activate General Ntlemeza. He has been put there to assist me. And when he indicated that, I just said, okay. And
You were not too excited about this, all this.
I was not excited. In fact, I was troubled.
You were troubled, yeah.
I was troubled. And I just felt, because I never considered my own safety to be in trouble. I worked in KZN, that is when I felt that my life was in really under threat. But when I was investigating rendition, I never, and more so because I knew the people I was investigating. I knew General Sibiya, I knew General Dramat, I knew Captain Malulek. I never thought they were anyhow capable. So now,
You thought they were not capable of putting your life in danger?
Yeah, I
or
never
anything.
thought they were capable.
Yeah.
That's why I just felt that it seems as they were implying that my life was in danger, or or without them, then I will really suffer harm. But the truth of the matter is that I never really.
You didn't feel threatened.
I never felt
in any
threatened.
way. Yeah.
Never felt threatened.
So in response to what he had to say, your response was like what? Okay.
I just said okay.
Yeah. And
Most of the time, and I think that's my tendency, when we are having a very relaxed discussion, I use okay as a dismissive rather than
as agreeing.
Rather than as agreeing.
Okay.
And then after that, he asked me about the case again, to say, what is that?
So, I'm sorry, when he said that General Mdluli had asked him to tell you that should you notice a suspicious car following you, you should activate General Ntlemeza. What did he mean? Did he mean you must phone General Ntlemeza? What did he mean?
I took as if he meant that General Ntlemeza will be the one who is taking care of my safety.
Or who would protect you?
Yeah.
Okay. Yeah, so just continue with the conversation then between yourself and General
Yeah, then he
Ntlemeza.
started to ask about
The case.
The case.
The investigation.
The investigation. And that is when I indicated that I still have to.
He was asking how far you were.
Yeah, what is that is delaying the finalization?
Yes.
Then I said, I'm battling to get hold of General Libya because he had signed one of the success report. There was his signature and some comments there. And I also informed him that I'd requested a warning statement from General Dramat. Now, at that time, I did not have General Libya's number. He's the one who got it for me.
He gave it to you there and then?
There and there. And no, I don't think he just produced the number.
Yes, yeah.
He might have made some calls.
Okay.
But what I remember vividly is that he looked for the number and he gave it to me.
Okay.
Yes. And then I had to call General Libya. And
While General Ntlemeza was there?
Yeah, and I put him on an open speaker. And that is when I indicated to him that, hey, General, I've been looking for you. And then he said to me, I can come to Pretoria. I'll be able to have a meeting with him. And then it was fine, it was concluded that way. After that, I served General Tlameza with refreshment and he left.
Okay. I think that's the right time to take the lunch adjournment. We are at 1:09. We are going to adjourn and resume at 2:10. We adjourn.
All rise.
There's only one thing he keeps on referring to you as captain. I think in those times he was a captain, then he got promoted to colonel. His statement the whole time was about colonel.